Okay, so we're moving forwards to look at formalities, and there's an exercise that we're going to do together on estates and interests. So what I'd like to do is do the exercise first, just so that we can start to see how this will interplay when we're looking at problem questions relating to land law and build upon an example. So in this session, what I'm going to do is start the exercise off looking at the estates and interests that we've previously encountered, and then I'm going to move on to formalities, and then next week what we'll do is we'll start putting some of that together again. We will look at the exercise again, we will recap on the estates and interests element for it, make sure that you're comfortable with that, and then move on to identify the correct form or documentary evidence that would be required to protect that estate or interest. So we're going to put those together, estates and interests, hopefully being a bit more clear after the last lecture, and we're going to look at how the rules apply to a situation. So we're looking at somebody's holding land and how estates and interests interweave within just one plot of land. And then we will very briefly touch on, there are quite detailed slides, but I'm going to look at the formalities introduction as just being that, really, because until you see how it applies to estates and interests, it's hard to grasp. So there will be some difficult material coming your way towards the end. Please don't worry about that in any way, because we've got another week next week to put more meat on the bones of that. I just wanted to start really getting your mind headed in that direction. So just to recap, already we've looked at the fact that the Law of Property Act section 1 sets out for us the fact that under 1.1 there are two forms of legal estate: the fee simple absolute in possession and the term of years absolute. So the freehold ownership of the land and a tenancy would both be capable of being legal estates. There would be 5 interests which are capable of being legal. We've looked at those again in terms of an easement that's capable of being legal, a rent charge, a mortgage, a second mortgage, and the landlord's right of entry. So we've got those 5 legal interests listed in section 1.2. Everything after that, and we looked at that, things like covenants, beneficial interests, obviously, estate contracts, so usually promises relating to the land, and equitable easements would be recognised as equitable under section 1.3, everything else becoming equitable. So we're going to now look and understand what that means in relation to a plot of land. So we have Ali as the freeholder of Greenacre. So we have Greenacre as a plot of land. The purchase of Greenacre, so the conveyance occurred because her mother, Yvonne, paid in 20% of the purchase price, and Yvonne also is a cohabitee, so Yvonne lives there too. So hopefully that's starting to crystallise some thoughts in your mind as to who these parties might be in the eyes of land law. These are the kind of common guardian ways that we might have recognised them previously as owner or freeholder, and we have a contributor or cohabitee, a parent who has helped. It's for us then as land lawyers to lay down the legal language on top of that. We have a purchase of property with a contribution, meaning that the freehold technically is divided. We don't appear to have Yvonne up on the legal title with Ali, so instead we can break down their contribution as an 80-20 split. And that happens down in equity. That's an equitable situation where a beneficial interest under a trust has been carved out for Yvonne. So we will have Ali as the freeholder and Yvonne as a beneficiary of the estate because she's put in that 20% hold in the land, and we have to recognise that that's what an interest is. So the estate will rest with Ali. Ali will have a form of legal estate. Yvonne will only ever have a beneficial interest or an equitable interest in the land. We can look at the legal statute towards the end of the exercise, but I'm just trying to get you comfortable with the language usage. So hopefully you will have identified that Ali would be the fee simple absolute in possession holder under section 11A of the Law of Property Act 1925. Yvonne, if she does not appear on the legal title, which she appears not to, she doesn't have any legal estate under section 11A. She doesn't have legal estate under section 11B because she's not a tenant. She would not have any of the legal interests under section 12 because she's not a bank, she's not a landlord, and she doesn't have an easement. So Yvonne's interest can only ever be equitable under section 13. Again, we'll recap that at the end of the exercise. Ali then grants the following interest over Greenacre. So if we've got a further party involved in the same plot of land, we have the same fee simple absolute in possession holder carving out other estates and interests from her own. So she has that legal estate that allowed her to possess and hold on to it, and now she's carving out other estates and interests from that point. She has carved out a right of way over the garden to her next door neighbour, Karen. So that promise between those two parties could become an easement. It's a right of way. That easement would need to look like it was freely given or time dependent, so given for 6 months, given for 10 years to Karen. In that way, that easement would be capable of being legal. It would look like it was freely given, like an owner, or it would look like it was term dependent, like a term of years absolute. In those two ways, under section 12A, that easement could become legal, and we will look at that together in terms of formalities then as to what document we would need to protect that legal easement. If it was just some sort of vague right given when it's raining in the winter, something that had some restriction to it but wasn't time dependent and time sensitive the way a tenancy is, it will be an equitable easement. It will not be capable of being legal. So that easement could be either legal or equitable depending on how it's framed and phrased. And we'll look at that in a bit more detail next week when we start to do the seminar on this area. So we have another interest being carved out by Ali's hold over the land. We have a promise being given to Dylan, another neighbour, that Greenacre will not be used for business purposes. So we have a promise restricting the use of that land and benefiting another party. So they have an interest in it. There's a covenant placed upon it to stop it being used for business purposes, and they will be able to protect that. So that covenant is a promise between Ali and Dylan. It's for Dylan to protect it and enforce it. It's a promise given to them. Ali remains the freeholder, the fee simple absolute and possession holder. We know that Dylan is not an owner. We know that Dylan is not one of the 5 listed in section 12. It's not an easement. He's not a bank, and he's not a landlord. So Dylan will only ever have an equitable interest in the land under section 13 of the Law of Property Act 1925. So we've looked at a beneficial interest under a trust being equitable. We've looked at an easement being potentially legal or equitable, and this covenant only ever being capable of being equitable. Now to the most important relationship in most property transactions, we have the bank. So Ali will have not just borrowed money from her mother in this situation, she will have borrowed the remainder of the purchase money. So the other 80% of the purchase money for Greenacre was provided by North Bank. So in effect, although Ali appears in the eyes of the law as the strongest party, the fee simple absolute and possession holder under section 11A, 20% of that property in the eyes of equity would belong to her mother, and 80% of the property in the eyes of the law belongs to the bank. So in essence, Ali's contribution to this property purchase is zero, but as the fee simple absolute and possession holder in the eyes of law, she holds all the power. So the mortgage has been given to the bank, so the mortgage is the interest in the land in return for the 80% remainder of the purchase monies. And that means that the bank have a very strong hold in the land, obviously. They aren't able to be recognised as the freeholder under the fee simple absolute and possession, section 11A. They are not the holder of a legal estate under section 11B, but they are protected as the holder of a charge over the property under section 1.2. So they are one of those properties, they are one of those parties recognised as being protected under section 1.2 and having a vested interest in the land. So it's important for you to know this and know how much it matters, because in the eyes of land law, when we're coming on to looking at registry, you will be able to see that the bank are the only party that are able to put themselves on at land registry twice. So their protection is huge. They have spread themselves across the register for the world at large to be able to see. So it's under that section 1.2c, a charge by way of legal mortgage, that they are unable to do that. They don't have a legal estate, but they do have a legal interest, and it's a very strong hold in the land. Again, Ali, as the fee simple absolute and possession holder, has the ability to carve out holds in the land in the form of estate, not just interests. So in this situation, Ali has carved out a 10-year lease over a workshop in the grounds. This lease has been created with Brenda. Again, Ali vests as the holder of the fee simple absolute and possession under section 11A. We should be able to quickly articulate and identify that Brenda has got the term of years absolute under a tenancy, section 11B of the Law of Property Act 1925. But it's also important to recognise that where we have a landlord, we will also have their ability to protect themselves by putting in a right of entry. So that right of entry arises because it becomes a legal interest in the land under section 1.2e. So Ali, as well as being the fee simple absolute and possession holder over all of the land, retains a right of entry over that leased property too under section 1.2e. And that qualifies Brenda's term of years absolute. That absolute hold and use of the workshop is tempered or is qualified in some way by the fact that obviously Ali is the freeholder and retains ownership of it. That hold on the right of entry is there to protect the landowner. Obviously, they have the holder of the freehold. They are able to enter the property and seize it whenever there is a default on the rent. they will also retain the right to inspect whenever that needs to happen. So what I've asked you to do in that exercise is to identify the estates which we've been talking through as it's happened. We've identified the interests as it's happened. And then also thinking about potentially whether those estates and interests could be legal or equitable. So that would be a problem scenario, asking you to look at a situation like that and articulate whether there are estates and interests, whether they're legal or equitable, etc. And it's for you to then, using statute, support your answer accordingly. So the estates, obviously Ali owning the freehold, the fee simple absolute in possession, would be articulated throughout that problem scenario. That's a legal estate that she holds under Section 11A of the Law of Property Act 1925. We already articulated and identified that Brenda owns the leasehold, the term of years absolute, that 10-year lease, is recognised as the second form of legal estate under Section 11B. As I discussed previously, Yvonne's 20% contribution to the purchase price, in the absence of her being on the legal title and sharing the fee simple absolute in possession ownership with Ali, she will only have a beneficial interest. That's not listed in Section 1.1. It's not listed in Section 1.2 as a legal interest or capable of being a legal interest. It can only ever be equitable under Section 1.3. Karen has an easement. We've looked at that. That right of way over the garden develops as an easement. It could be legal under Section 1.2a if it is freely given, so it looks like a fee simple absolute in possession, it looks like ownership, and or it's given for a specific time period, a term of years absolute. If it's not given in that way, it could become equitable under Section 1.3. So it's quite important that you recognise that an equitable easement could also be an option there. Dylan having the restrictive covenant, so the ability to restrict the use of the property and stop it being used for business, can only ever be equitable. And we've looked at that because it's not listed in Section 1.1, it's not listed in Section 1.2 as the 5 types of legal interest available. It could only ever be equitable under Section 1.3. And finally, the bank's mortgage. The bank will have a mortgage, the interest in the property, in return for money. We know that that is a very strong hold in the land. It's not legal estate under Section 1.1a, but it is legal interest under Section 1.2c, and that protects their hold in the land in return for the purchase price. Again, as already noted, Ali should also retain her landlord's right of entry. It's protected under Section 1.2 as well. It's a recognisable legal interest in land under Section 1.2e. Ali's ability to retain and return the land to herself, enter and return the land to herself on non-payment of rent and or to enter for inspection, etc. So that's the exercise I wanted to cover with you, and hopefully that makes more sense of how you're looking at a plot of land and how you're establishing whether somebody might have an estate in land, there only being 2, a legal interest, there only being 5, and then a process of elimination as to whether there might be an equitable interest, everything else falling under Section 1.3. In terms of formalities, we already looked at this previously, but I need to kind of keep pushing it into place in terms of establishing how to protect those estates and interests and affixing and attaching them to the land in some way. We can tell that any sale of land or any interest would be void unless that legal estate or interest is made by deed. So in order to transfer the fee simple absolute possession ownership over to another party, or in order to establish that you have a legal interest in the land, so your easement, your mortgage, your landlord's right of entry, all of that would be protected by deed. And that's exactly what is stated. In order to be valid, in order to be that legal estate or interest, it should have been executed by deed. And that means that it's a heightened form of evidence. It's a stronger form of legal document, because a deed has to have on the face of it that it is a deed. Under Section 1 of the Law of Property Miscellaneous Provisions Act, subsection 2A, the deed itself has to refer to itself as a deed. It has to recognisably be a deed. So it usually states something like that, this deed of transfer. So that's a transfer document that's transferring the fee simple absolute and possession holder over from one party to another through that deed or that document. In order to then, under Section 1(2)b, be validly executed, it would have to be signed, it would have to be witnessed, and it will have to be delivered to the interested party and or their solicitor under Section 1(3). So that is very formatted, it's very restricted, and rightly so, because these legal estates, the 2 legal estates and the 5 legal interests, are of such a strong hold and of such importance that they have to have that strong documentary evidence. They have to be protected by a document of such substance and import. So they will usually be signed, witnessed at a solicitor's or in some more formal way, and then delivered. So when you need one under Section 52 to be able to create any legal estate or interest, so any mortgage, any ownership, any easement, or to transfer them, they would have to be made by deed. So from the creation of the thing, the creation of the mortgage over a property, or the transfer of some hold in the property that is capable of being legal, it would have to be made by deed. If it's not made by deed, it can't be legal. It would have to be made by contract. So a legal estate or a legal interest has to have a deed. If it's not got a deed, it's going to be equitable and it's going to need a contract. The only exceptions to that being under section, there are 2 exceptions. The main exception would be for transferring the term of years absolute, so transferring or creating a tenancy. If it falls under 3 years, you do not need a deed. So short-term lease under Section 54(2) of the Law of Property Act 1925, you do not need a deed for, because obviously if every 6 months lease or 1 year lease was made by deed, then it would be very expensive and time consuming. So as we've looked at previously, for a legal estate or interest to be capable of being legal, it must have been listed in Section 1(1) or 1(2), 2 legal estates, 5 legal interests, and then it has to have the right document on top attached to that estate or interest in order to fully bind it and make it legal. I think I used a shepherd's pie analogy. So only mince and onions without the potato on top. We've got to put the right document on it in order to fully execute it. So if it's not listed in section 1.1 or 1.2, or it's not been made by a deed, then it's only ever going to be equitable. So if it falls into the section 1 to 3 category, anything else, not those 2 and 5, or it did fall into 1 and 2 but didn't have the right document on it, then it will become equitable. For equitable, we, again, as property lawyers, really do require there to be some writing. There are 2 main exceptions, as we've already looked at, the short-term lease, and there would be an exception where there's a beneficial interest in land under a trust. The I love you, you love me situation, we wouldn't expect writing in that situation because it's usually coming from a point of love and relationship and cohabitation, and people in relationships like that don't behave in a way that indicates that how they hold land in writing in every instance. So the formalities are relaxed where it comes to a beneficial interest under a trust, usually a cohabiting couple. But where the formality exists, where we're looking for that contract under Section 2 of the Law of Property Miscellaneous Provisions Act 1989, we're wanting a document in writing signed by both parties and containing the terms of that agreement. So as property lawyers, we are always looking for a piece of paper. We're either looking for the deed to make it legal, or we're looking for the contract that establishes the fact that there's an equitable interest and what the terms are of that. The only 2 exceptions that we recognise would be a lease under 3 years or a beneficial interest under a trust. Those are the situations where there is more flex because they aren't seen to be as formal. So in summary, there are 2 legal estates and 5 legal interests, everything else being equitable. If it is capable of being legal, so Section 1.1 and Section 1.2, then it will need a deed in order to make it so. The only exception to the need for a deed under Section 54.2 being that legal estate of the term of years absolute that is under 3 years. A short-term lease does not need a deed. Equitable interests, so the everything else under Section 1.3, we ideally need to be in writing. Again, the only exception to that rule being a beneficial interest under a trust, where people usually don't behave that way towards each other. So there endeth the lesson. So again, what I need us to know going forward, I want you to look at that exercise that we just did a moment ago and make sure that you're bedded into understanding and looking at a plot of land and seeing how the fee simple absolute and possession holder carves out these other forms of legal estates and interests, and whether then there could be an equitable interest aside from those. So 2 legal estates, 5 legal interests, everything else being equitable. And once you've recapped the exercise that's in this lecture and gotten to grips with it a bit more, I'd like you maybe to go back through it again and start to think about what evidentiary requirement there might be, what documentary evidence might we need for each of those. Thank you very much for your attention, and I look forward to seeing you in class. Please do interact with the discussion fora as and when they become available. It's very important that you do so. Thank you.